Hi folks, Bruce Colodny here, the California gun attorney, GunLaw.com. For over 30 years I've been very busy here defending gun owners in California, the state which without question in my opinion has the strictest state gun laws in the entire United States. This video is one of 3 that I've made discussing the common reasons why people lose their gun rights. People lose their gun rights in California because of involuntary mental health detentions. They become subject to certain restraining orders, or as the subject of this video is, they have a criminal record. Now, in California and anywhere in the United States, if you're convicted of a felony, subject to very, very limited exceptions, you're prohibited from firearms. And in California, some misdemeanor convictions make you prohibited from firearms. Also, under federal law, once you're charged with you've formally been charged with felony crimes, you're prohibited from purchasing or otherwise receiving firearms or ammunition. You can still keep the guns that you already have and the ammunition you already have under federal law, although it's very, very common as a condition of being released on a reasonable amount of bail or on your signature, the judge will also order you not to possess firearms or ammunition. Now, let's get back to California. And first, a bit of history. Until 1991 in California, you wouldn't lose your gun rights for criminal reasons unless you were convicted of a felony or certain misdemeanors. Just a few misdemeanors, though. Then what happened is we had a horrible tragedy at an elementary school in Stockton, California in 1989. And that just opened the floodgates for new gun laws in California. One of the things that happened as a result of that 1989 schoolyard shooting, besides the assault weapon prohibition and extending our waiting period from handgun purchases to rifle and shotgun purchases, was a list of so-called 10-year misdemeanors was created. And this 10-year list of misdemeanors, and that's 10 years from date of conviction, you lose is the loss of gun rights. Some of them don't involve any violence. For example, in California, if you're convicted of selling a handgun, if you suffer a misdemeanor conviction for selling a handgun to your neighbor who's lived across the street from you for 25 years and you sold it direct rather than having the sale processed through a licensed dealer, you're prohibited from firearms under California law for a period of 10 years. Now, keep in mind that in California, when you're prohibited from firearms, that prohibition is any type of firearm, whether it's classified under federal law as a modern firearm, in other words, a cartridge gun manufactured after the year 1898, or an antique firearm, any firearm manufactured before the year 1899, or a muzzle-loading firearm such as a cap-and-ball revolver that does not use fixed ammunition. You're also prohibited from possessing a firearm frame or receiver, from possessing ammunition or ammunition reloading components, and you're prohibited from possessing ammunition magazines, clips, speed loaders, any type of ammunition feeding device. Now, people often ask me, I was convicted of a crime, but I had it expunged. And expunged in California refers to an order under Penal Code Section 1203.4. But when you think of expungement, most people think, all right, my conviction was expunged, I've got a clean slate, I'm no longer subject to any penalties or disability. Not true. When you first read about, or you start to read an order expunging your criminal conviction under 1203.4, it'll usually recite that your guilty plea or no contest plea was withdrawn, a not guilty plea was entered, and the case was dismissed. So the average person will think, great, I no longer have a conviction. But when you keep reading, it'll tell you that it doesn't restore your gun rights. Now, that's one type of what I would call post-conviction relief. Another type that often does restore your gun rights is what's known as a 17B motion. Now, to explain what and by the way, these numbers all come from the California Penal Code. In order to explain what a 17B motion is, I have to tell you what a wobbler is. Now, wobbler is a slang term used in the California criminal justice system by defense attorneys like myself, by district attorneys, and by judges. And what it refers to, in California, we have hundreds of crimes that can be filed, in other words, charged by the DA as either a felony or a misdemeanor. And if the DA opts to file it as a felony, at certain stages of the case, the judge has authority and discretion to declare it reduced to a misdemeanor for all purposes. An example would be receiving stolen property or possessing stolen property as a wobbler. Now, if you've been convicted of one of these crimes that's known as a wobbler in California, after you finish probation, you can return to court and ask the judge to order it reduced to a misdemeanor for all purposes. And if there's no other firearm prohibiting event in your background, subject to a few exceptions, that will restore your gun rights under current California and federal law. Some of the exceptions are if you were convicted of a felony of domestic violence, which is a violation of Penal Code Section 273.5, and it's ordered reduced to a misdemeanor, you're still prohibited under the federal domestic violence prohibition. Also, if you are, we have something in California called assault with a deadly weapon, Penal Code 245. It is one of these wobbler crimes. However, you should know that if you're convicted of 245A1, which is assault causing great bodily injury or assault with a deadly weapon, with the weapon being other than a firearm, as a misdemeanor, it's one of those 10-year misdemeanors, so no guns for 10 years. However, if you're convicted of a Penal Code 245A2, assault with a deadly weapon, with the weapon being a firearm, even if it's ordered reduced to a misdemeanor, it's a lifetime prohibition under California law. So, also now, what if your felony conviction is not one of these wobbler felonies? Sometimes they're referred to in California as a straight felony. Well, folks, if that's your situation, you're going to need a full and unconditional pardon from the governor of California. And he does grant some. In fact, he's been relatively generous compared to some of his predecessors. However, there are some restrictions on the governor's authority to grant you a pardon. For example, if you've ever been convicted of a felony involving the use of a dangerous weapon, the governor is still allowed to grant you a pardon, but he's not allowed to include restoration of your gun rights in that pardon. Ever since I first worked on a pardon application back in the 1980s, the governors in California have had a policy that, absent very unusual circumstances, they will not consider somebody for a pardon until they can demonstrate at least 10 years of rehabilitation, with that 10-year period beginning not at the time of conviction, but after their probation or parole has ended. Finally, if you've been convicted of a felony, a straight felony, in 2 or more court cases, the governor cannot grant you a pardon unless and until he obtains the approval of a majority of justices on the California Supreme Court. Also, again, beware, if you're formally charged with a felony, federal law says you cannot purchase or otherwise receive firearms or ammunition. And even though you can, under that federal law, you can keep the firearms and ammunition you already have, it's a very common condition of being granted bail, having your bail set at a manageable level, or being released on your signature promise to appear, that you turn in and not the guns and ammunition you already have and not acquire more. All right, if you have a criminal record or you have any other legal problem involving firearms, please contact my office. You can call us at 1-800-560-8000. Please also visit my website, GunLaw.com, for more information on the restoration of gun rights, many other subjects, the common legal hazards for gun owners in California. We've got some entertaining articles on some of the idiosyncrasies, and there's actually a little bit of humor in gun law, not much. It's usually pretty dismal in California. All right, and finally, I'm a lawyer, so here's the disclaimer. The information in this video is general information only. If you need advice on your own particular situation, please contact us, speak to me. This information is current when this video was made, however, it's subject to change. If we have new laws enacted in California, and every year we seem to have a slew of new draconian gun laws introduced into the legislature, and many of them unfortunately are passed. But on the bright side, the Pro-Second Amendment community in the United States has been very generous in its support of challenges to these gun laws, which I think the vast majority of which I believe are unconstitutional. We've had some great victories in court the last 10 years, starting with the landmark Heller and McDonald opinions by the United States Supreme Court. Okay, that's it, folks. Happy hunting, good shooting, and see you in the next video.